Legal disclaimer, of course, we start off with that every meeting is it's private and it's meant for members only. It's not legal or tax advice. Anything you hear here should be thoroughly researched, doing your own, um, your own homework, right? And so just keep understand that's always your responsibility. It's not my job to do your case law research or to research something for you. That's yours. We just try to give you the directions and where to go and what to do and how to grow for yourself. Because ultimately you're out there on the battlefield. We're not there with you. We're not your attorney. And we can't possibly do that. It's only one of me to answer all these questions people have. So we do pretty good with just keeping it at that. And so keep that in mind. If you want to learn more about status, trusts, and really the most advanced tax strategy we cover, check out the trust and status coaching information. That's yourlaw.org/status info. It's also the same link that goes to trust info. It's not listed there, but status info will get you there. And if you're kind of facing a no crime situation, no victim crime situation, check out Slam Dunk. That is strictly for people that are in pre-trial, not you haven't already done a plea, you haven't already gone to trial, or you're not already in prison or going to prison. This is just very early. The thing is just starting. That's the one type of criminal matter we can coach you on. All right. You also know how to communicate with us. All this information is there on the premium member page, Telegram, Proton Mail, email. So be sure you use those resources. Know how to get to the downloads. I get this question a lot. People they open one of the downloads and then they ask to edit. Well, what you're seeing is a visual image of what is in our system. We can't let you edit our version. You have to download it. And so you click File, Download, just like you would any other program. So just make sure you use the download function to get to those documents. We've already covered the support process and issues there. Let's see here. So what I want to cover briefly, again, because so many people are coming on board right now, is where to get the information on the debt, the delete debt, and course for what we call now the new gold level premium membership. And go to this page here, go to join and hit delete debt course gold level, and you'll get that information if you want to find out about that upgrade. A lot of you here tonight are probably already doing it. We've had a record number of people signing up quickly under this program. When you see what we're offering, you'll see why. The annual cost of the membership will be recovered almost instantly in current credit situations we can help you resolve if you follow through. So it's like anything, you got to use it too. But be sure you check that out. And tonight, I'm probably going to have some questions from people who have just joined it, but I'm going to open up the questions tonight for everybody. But this is just, I know that because so many people are new, this is not the official gold member class. For those of you who are in that class, this is our general premium member class. So we'll address a broader range of issues, but I just wanted you to know that first live Q&A, we'll start doing some of those for the gold class only. It'll be separate from this. I don't have the time quite set yet. I'm thinking Wednesday evenings about the same time, a couple of times a month. But in the meantime, what we're doing is with that program, I'm going to let you guys actually peek inside under the hood, if you will. Once you're accessing it, what the page will look like and what content is there. Starts off with a pretty extensive video on how the whole process works. It's very much a verification of debt process. And then it gets to a very detailed written course. Plus, there's going to be some additional downloads and such. And then there's different modules, step 1, step 2, step 3, sometimes called session 1, 2, 3, 4. But these are the steps you go through in a verification process in detail. And these are more advanced letters, more advanced methodologies of pushing all the way through to getting them to settle with you and get the account closed and get it off your credit. These are, of course, for commercial bank type debts, which could be credit cards, student loans, the unsecured ones mostly, private, but not really private party contract loans. These are loans where you created the money through the commercial system by your application. And so it shows you how to show they don't have standing, they can't prove the debt, and you can push them all the way right into, especially if it goes to a collection agency, that's like a guaranteed win. Almost. I can't say anything's guaranteed 100%, but that's about as good as it gets. And this will tell you how to push it to that process. Meanwhile, getting it off your credit so it's not damaging your credit while you're doing it. That's very important. Again, covers a broad range of commercial bank type debt. Later in the course, we will cover a little bit on mortgages and car loans as well, but you have to know the foundations first. So we're going to be releasing this over time, over the next several months. The modules will come out. So rather than charging a large amount up front, we have a monthly subscription. And as we launch more information, you'll get the next information and so on. I'm pretty sure most people, from what we've got in terms of information to put out there, will be staying with us for a long time on that. It's well worth it. It's an investment to be able to wipe out most of your debt. Many, many, many times over the cost of the program. And then we have on this page, you'll also see a bunch of future modules that are coming in. How to do small claims court. We'll talk about arbitration. That's what we can use to stop like the collection of a car or a house. And even get into some of the bill of exchange systems that are out now that are being more effective. This doesn't get into what like we did with the equity course. It's a different methodology. It's a similar concept, but it's a different methodology. We're only going to use things that have enforcement teeth. So many processes out there are great up till the part where you've got to enforce it. And so we're going to only try to bring out things that have some level of decent enforcement ability to make it stick. That's our goal. So you can get over here again. You can just go to our join and upgrade page, delete debt course, gold level information. Like again, some of you have already joined this. You already know where this is. So make sure you know how to get to the member page. But I always, people forget, just go to the member pages and the courses you have access to will pop up. If you're not, for example, in the status and wealth protection coaching, you won't see this link. But if you're in the gold level membership, you'll see this here. And if you're not there yet, then you probably need to upgrade. So go to the join and upgrade coaching section here. Okay. All right. So I want to start off with, again, I always do this with most of our meetings. You'll be able to raise your hand. And I'm going to start off with success stories, something you've done that's been successful. And because I don't have a big teaching lesson tonight, all that's in those who've joined the gold member, go watch the video, go read the modules, start getting your you can copy and paste and make your documents, do all that stuff as you're learning the course. Just don't throw it out there.
Right.
This is far simpler, what we're doing now, because it's simply based upon they can't verify the debt, then they have no standing.
They can't testify. They can't testify. If they testify, then.
But you can testify, and most people go in there and testify, and that's the problem. You got to get you not to do that.
Okay, and put the burden of proof on them.
Exactly. That's the main focus of this program. So that's you're on the right track with what you're doing, but you have to have a completion plan. And this process we're teaching tells you how to go in as a defendant or as a plaintiff, suing them to prove their claim, and now charging them with violations of multiple federal laws. They do it all the time. People don't believe, they don't violate, they couldn't be violating the law all the time. Yeah, they pretty much do all the time. It's pretty amazing how, but they know that the average consumer doesn't know this, and they also know that the average lawyer won't bring it up.
Okay, so studying the beat case with a lawyer, would that help me as far as if I?
It'll always help you because you'll understand the courts. You'll understand
right.
procedures, motions. You mean if we do what we're teaching you correctly, and you start early in the process, you won't be in court. But in case you are, now you've built a record up that you can use in that situation if needed. If you don't have a record, you'll lose a case.
Yeah, right. You gotta save all the certified mailing. Gotta have everything.
Right? You're right. You verified when they show up, you gotta say objection, Your Honor. This matter is already resolved administratively. Here's my evidence.
Okay, and
that's where you want to be. You don't want to go to court and fight.
I know it works because it worked for me. I sent one letter out, and they just took it off my credit report, and they stopped doing it. But it was just the other collection. So I know it worked.
Some of them go further. Some of them are coming at different times. Some of them are different creditors who act a little differently. You just got to know enough rules to how to. The key with it is staying on your square, staying on point. Just When I say send 3 letters the first month, I mean send them and on time, no matter what happens. Don't think it's because they went silent, you can just ignore it because
Right.
they might pop up later. And if you've already built your record, then you can say, hey, here's a copy of what you already failed to respond to when you're ready to respond. Otherwise, cease and desist.
Okay, and one more question. I'm gonna leave. Not leave. I'm gonna get up for other people. And so it's the 10 day. Once you give them that notice, like you said in the fire, you gotta talk to your brother first and probably let him know before you take him to court. The 10 days. Is that the longest? That's the maximum amount of time you can give them,
It's just,
or like.
I just find it's best. There's no set law that says this, but there's generally guidelines for giving people opportunity to respond. Because if you rush it, they'll say, "Well, you only gave us 3 days." Well, that would be unreasonable. The court it depends on the judge. He may say, "Well, that isn't reasonable." So you give them plenty of time. I give them initial letter, then a day 14 letter, then a day 30 letter, and then on day 32, I'm starting to let them know I'm filing something.
Okay. All right.
You
So
don't
you
waste
gotta
around.
have. All right. All right. Thank you, TJ.
You bet. But
All right.
you always give the other guy a fair opportunity. That's a biblical principle. Okay, next one, Daniel.
Oh.
Yes, hey TJ, how are you?
Good.
Good. My local small claims court has a list of rules that I was going through, and one of those rules was that they said you cannot sue someone in small claims court who does not live in the county. So I guess that's kind of when you talk about, processes that have teeth behind them,
Yeah.
enforceable.
Your
I'm
mic's giving you this really weird noise, but go keep going. I can hear you, I think.
Um, so is the enforceable part the small claims court? And if so, can you go to like a neighboring county to enforce?
You could, but see, remember, when you send the letters, you're going to let them know that, hey, we're going to hear this here. You're coming in if they're coming from out of state, they don't have a license in that state. That's a problem already for them.
Hmm. Yeah, I just since I didn't have since my small claims court had a rule that you can't sue someone from outside of the county, I was just curious about how to
Well, remember
enforce.
that company's doing business in the county.
Okay,
So
because they're doing business with me who lives in the county.
exactly, that's your position.
Okay, so I could just say that to the court if they
Yeah.
challenged me on that.
Yeah.
Okay, gotcha. And then the second question I had was when they respond, and they send, they don't necessarily answer all your questions, but they say, here's the account, and they show like a picture of the numbers from, the alleged debt that they had with the original
Yeah.
creditor.
Which it doesn't mean anything.
Yeah, so what is the response to that? Do I just say this doesn't mean
Then
anything?
what depend well, your letter is your response is, well, I asked you for these 10 things.
Hmm.
I want the internal accounting. I want to know about your insurance claims, your tax benefits you've taken. I want to know about the original ledgers that where you issued money. None of that has to do with the bills they give you.
Hmm.
But that's not, you don't ask for the accounting. You ask for this very specific set of accounting
Hmm.
as one thing as many things you're asking for. We have a pretty good list of things you ask for. And if they don't respond, then what do you think you can say?
And I guess if they didn't specifically give
They
what I was
failed to
asking
respond
for,
point by
then I
point.
could say, well, you defaulted.
They have no standing now. Key is get them to the point where they have no standing because they have no claim. They failed to prove the debt. The log is very specific. You have the right to verify the debt, and there's just the fact that they say that there's a statement isn't who's swearing to that under penalty of perjury that that's true.
I didn't see any swearing. I just saw
No,
just
no, because they can't. How could they swear that that's true?
you're
They
saying
don't
because
have
they're the ones
firsthand knowledge of
that
those
bought it.
charges. See, they want you to do it though. They'll say, "Is this your bill?" And you say, "Yeah." They go, "Boom, case closed." See, as soon as you testify, that's a testifying.
Mm-hmm.
You're going to lose. You have to say, "Well, Your Honor, I'm not here about that. I'm here about, well, I want verification of the debt. They didn't verify. Here's my proof. One, two, three, 4 letters that went out.
Gotcha.
The response wasn't a response. It was incomplete."
Okay.
So anyway, we cover that in some more of the training in the small courts part of the training, small claims part. That'll be the next one we actually finish posting. But yeah, that's where you're going with it.
Okay.
They lack standing.
Okay. And then for the fair debt collection practices, the $1,000 fee, is there just can you charge that to like multiple people or
Yeah,
multiple
it's actually in the
agents?
course. We talk about how when you file a claim against him, if there's say like three people that you're dealing with, maybe an agency, a lawyer, the banker, whatever names you can get, you file one on each one of them. You file them each a separate suit. They have to each show up for.
Okay, so you wouldn't do
And
it
guess
all
what?
in
If
one
one of them
suit,
defaults,
even if
they all
there's
default,
three.
and they're not going to show up.
Yeah. So you would advise to do like three separate suits rather than try to get them all
Yeah,
in
yeah.
one. Okay.
Again, that's something we kind of cover in detail in the course that you're going to cover. You're going to sue, and for each type of dispute. I mean, if they don't answer it, that's not verifying the debt.
Hmm.
So there's a chart, and I don't have the chart handy here, but there's a chart in the course of all the potential things that they could do. It's pretty extensive, and you can file a separate suit for each violation against each individual. So if there's like three violations and three people, okay,
Hmm.
well that's six potential $1,000 checks you can pick up.
Hmm.
And once
And
you
with
get to the point where they got to pay you the check, they'll start settling with you. That's how but you don't push it to that level, then, they'll know you backed off.
okay.
That's key.
Um, when you file that with the small claims court, you try to get it
And
all
by the
set
way,
up.
you can file those partially as claims just with the agencies that oversee this as well. So, they may just cave on doing that before you go to court if you want to do it that way.
You're just saying send it to their billing
No,
department or
you let them know
whatever.
I'm filing a claim with on the Fair Debt Collection Practices Act
Hmm.
with the agency that oversees that. They all have complaint processes.
Okay.
I always recommend doing one of those before you go to court, just in case, because the goal here is not to go to court. The goal is to get them to go away and probably pay you settlements.
Hmm.
Maybe. I don't want to hold your breath on that, but it's really something. I mean, I've known one guy I learned a lot from years ago. He made a full-time living doing this, going after debt collectors because there's so many mistakes they make, filing the claims, they come out and settle. And he was helping people doing it that way. Um, not something I recommend doing for other people, but that's what he did, and that's where I developed a lot of the background on some of this.
Hmm. Okay. Well, I am a gold premium member already, so I'm looking forward to
Okay.
seeing what unfolds. Thanks very much for
Well,
all the
just
work
keep
you
digging in
do.
there. You'll see updates every week, new content, new updates to the pages. It's just kind of gradually being edited and posted. And then once a good section's posted, we'll cut the video and there'll be more of a video training. The video training really goes over what's in writing anyway, but sometimes people want both dimensions. So we're going to make sure it's really comprehensive. Okay, Bradley, I think you're
Yeah,
back.
yeah, okay. Hopefully a quick question. Do you do anything like do you go through Canadian law at all or is it just you're just working in US
Yeah,
law?
I don't know anything about Canadian law or Australian law or French law, or I mean, because honestly, it's a lot just to know ours, but the acts that we base a lot of it on can be cross-referenced. There's probably similar types of acts because the international banking system is what we're operating under. It's not just the U.S. banking system, and this whole thing, the courts, everything are under a banking system. The International Monetary Fund, the where all debts. There's only like three countries that aren't operating under this system. And they're the ones that are the public enemy number one: North Korea, Iran, and I forget the other one. I don't know, it was Venezuela. But anyway, basically there's just these super out of the system communist countries that don't play along with the banking system. Otherwise, everybody else is kind of in it, and some of these rules apply generally. They've been pretty much duplicated in many countries, but you have to do the extra due diligence. It's like if I use a case from California and I'm in Oregon, I can't use that case law. I got to go find something similar here or a law that's similar. Sometimes they have different titles and different names, but the subject is there. So you have to just get accustomed to how to do searches. And one good tool is Google Scholar here. But also most states have websites, courts have websites. You can look up the statutes and search for subjects and try to find the ones that are similar.
Okay,
Use
thank
that.
you.
Yep.
Basically 150,000 defaulted on about 6 or something like that, cards,
Credit
around,
cards. Okay.
yeah, um, 2018, 2019, I did a deal with a guy who was supposed to make payments on the cards. He used my credit, and after a while, he was unable to make the payments. I defaulted. So, will this be helpful for a situation like that?
Well, and we can't help you with your friend's relationship issue, but as far as the defaulted debt, what do you have debt collectors contacting you now?
Oh, they stopped, a few years ago.
Okay. Well, if they're still reporting them though, you'll be able to go in and you have to kind of find out where you're at on those things, but you definitely want to start sending some stuff out to get those verified. And you start off with the credit bureaus as well as the last people that sent you letters and start sending them letters and say, hey, if you don't verify this within 30 days, I need to have you remove it from the credit. And then once they remove it and they're not moving forward on it, it's pretty much over. I mean, technically, somebody could sell it to another debt collector, which commonly happens, and then they start over. You just do the same process again with them.
It's probably not cold.
Oh, okay. So basically, even if it's a few years old, I could send verification or validation letters
Sure,
to
if you're
the.
concerned about it showing up on your credit or that they're still doing something, you start with the validations. Yeah.
So first with, so I would start first with the credit reporting agencies.
Yeah,
Maybe.
I'd get a credit report, get a new credit report from each of the three agencies, get a physical copy, review them carefully, read them really, really carefully. Take time, highlight them, and anything on there that's affecting you negatively, you can remove. I'll give you a quick tip. It's in the credit course, but one of the things you can do right away is look for any old phone numbers, any old names, any old addresses, and tell them those are inaccurate because they're not current.
Yeah.
And then once those actually help your score. But then, yeah, go after and look and see who's reported something. If a debt collector has reported a delinquent debt, they never had authorization from you to that specific company to use your social security number for profit. And they're profiting by just putting it on your credit bureau. So you're going after the credit bureau for even having it on there.
Yeah. Well, they're not authorized. No one's authorized to use my information. It would be like identity theft,
Yeah,
right?
and essentially that's what they do, and they use it for profit by dinging up your credit, by putting it on the credit bureau itself. Well, they're making money by reporting that stuff. I mean, for example, a judgment shouldn't appear on your credit because that would mean that the court released information on your social security number without your permission and put it in the public record. See,
Hmm.
people don't see that like, well, they can do that, can't they? Actually, we'll show you where to look up the laws. You'll see that they can't, but they do it all the time. And as soon as you catch them on it, they should remove it and they might owe you some money.
Okay. Are those things all contained within your sample letters, which I've started to look at?
Yeah, there should be, yeah. Now you may have to tweak them because of your current situation. Obviously, any letter you see from us there's no such thing as a template. There is a starting point. In other words, it's got to fit your circumstances. So read it carefully, write it carefully, make it sure it fits the current circumstances. But yes, the 30, 14 and 30-day letters, no, the day 1, 14 and 30-day letters are posted now in the course material and also the credit bureau information on how to start tackling the credit bureau. Okay. You'll have to do both of those probably. And just start whittling at them. Just got to, and if they've gone away and all they're doing is reporting on your credit, but you still want to contact that company and say, hey, you're violating my rights by reporting this information. Where's your written permission? They don't have it. Oh, well, then you owe me money. You just kind of come at it
Okay.
from that angle. Same with the credit bureaus. They need to validate the debt that's on there. And if the company won't validate, then they have to remove it. And they probably won't validate.
Right. So start with the credit bureaus. Now the 14 and 30 day, that has to do with the credit bureaus, right?
Well, that has to do with responding to any creditor. And then there's some letters in there about credit bureaus as well. The credit bureaus are a little bit different timing. I'm dealing with where somebody's coming after you for a debt. You want to hit them with those 3 letters right away. And then you
Okay.
take all that over to the credit bureau and say, hey, look, they didn't validate anything. Remove it until they do. And they won't. And
Okay.
9 times out of 10, they won't anyway.
Yeah, but would I start with the credit bureaus and then
It's all in
go?
there. Look, just to go through the course material. I don't
Mhm.
want to repeat everything that's
Oh,
there because
okay.
it
Okay.
describes about what to do and when, depending on your given situation.
Oh, okay.
Yeah, I won't repeat the whole course here. It's
Okay.
extensive.
Yeah, I
It's in
understand.
there. It's in there.
Oh, okay. Well, thank you, TJ.
You bet. Welcome aboard. Good
Thank
luck.
you.
Let us know how you do. By the way, anybody here who starts using this stuff, as soon as you get a response letter, something where they say, hey, we quit, you need to get a picture of that and send it to us. We need more and more testimonials. That's going to help others see that, hey, what they're doing is real. It works because we already know it is. And we have a whole lot of testimonials, but not from this class. I want them from this class. So, okay. Ginger, I think you're next.
Hello, I have a Bank of America credit card, which I was served on May 17th, and I just filed for a 60-day continuance.
Okay.
Would this course be able to help me with the being served?
Well, you've already been served, it sounds like. And
Yes.
you reply with a continuance. So you actually have activated the case, but start hitting them with the letters. Same thing with the credit bureaus. You got to establish their non-response. Okay. You're at a good time because it actually hasn't started yet, and then you're going to use those non-responses if necessary. If it goes into court, this is where the how to win in court course kind of comes in. You're going to do some of the same stuff in the form of discovery requests,
Okay.
and
So this course would be good for the debt with the debt one?
that's what it's for.
Okay,
Yeah,
perfect.
it's
Yeah, I
for
did send the opportunity to cure and notice of fault
okay.
to the debt collector, which are acting as and the attorney. They actually listed Bank of
Yeah.
America
Well,
on.
look at our debt collector letters too, and just see if there's anything else you're missing. You could still throw something else at them. Like, for example, they're representing themselves as a attorney when really they're a debt collector, and it's the misrepresentation parts, the no contract parts that are a problem. So yeah, keep building your record, and then ultimately, if they want to push forward and they don't settle, you want to push them to where you almost have a counterclaim going into small claims, and
Okay.
and then you ask them to cease and desist till that matter is resolved. That's another thing you can do. But you got to be pretty aggressive since you got 60 days. You want to get those out there, build your record, bring it in and say, who is this guy? This guy over here, can he testify to any firsthand knowledge of this account? He can't. Your Honor, there's no witness. Therefore, there's no evidence. An
Yeah, and
evidence without a
seriously.
witness is not evidence.
Right.
Okay.
Well, I haven't been granted the 60 days. I just asked for it yesterday.
Okay. Well, you do have some of the stuff you've sent. Take a look at what's in the course too, though, and see, hey, I missed this, or I should have sent that. Then you might have to adapt things a little bit. As long as
Okay,
you're hammering them, that's the key.
great. Thank you. I appreciate it.
You bet. Good luck. Let us know how you do.
Well, you will know.
Okay, sounds
Thank
good.
you.
Anybody else raising a Justin? I see.
Hi, TJ. How are you?
Good. How you doing?
I'm doing okay. TJ, I'm already signed up, so I don't have to wait until you release the small claims class. I can just go ahead and start sending my letters out.
Yeah, the small claims thing is something you do after you've built this record up. So you
Okay.
want to already have that in place before you file small claims anyway. You can go down to small claims court and get their kit. They have a little kit on how to sue and how the procedures work. You got to learn that. We don't give you that because it's different per every court. But in the meantime, you need to build your record up so you have something to go to small claims with.
Okay.
Receipts, mailings, so forth.
Uh, is it a good idea, TJ, to have a third party mail it out? Maybe just any anybody or
I
even a
really don't,
notary?
it's not a bad idea because you can have that person be a witness acting what was sent and received. They would have to be the return address on everything to witness it. So they have to see it both ways. So you'd have to adjust the wording and the documentation accordingly. Maybe give them a power of attorney if you want to have a witness. I'm finding it's not really always needed, but every little thing you can layer on sometimes helps, but don't make it so hard that you don't get it done either.
Okay.
Your certified mail is a
Good enough.
legal document. You're going to swear under penalties of perjury anyway. What witness will they have that'll swear under penalty of perjury of anything? The lawyer can't.
Right.
And typically the lawyers won't even go to small claims court. They'll want to settle with you first.
Okay. And also, TJ, is it a good idea also to do two originals? Because from what I know, I don't know if it's correct that in court you can only file or
Yeah,
submit.
when you mail your stuff off, just send copies. You don't just keep your originals for your court copy.
Okay. Okay. Cool.
You keep the originals and just send copies. That's sufficient notice to them.
Okay. Good. All right. Thank you, TJ.
Okay, that was easy. Good stuff. Jeff, how you doing? Jeff, oops, sorry. I thought I unmuted you. How about now?
Unmute. There we go. How's that?
There you go.
Hey, real quick, I'm in litigation with a third party debt collector right now. I've been accepting with notices of acceptance. I'm a gold member, kind of getting into the beginning stages of things. Should I shift my focus as far as getting these letters moving? They did, FYI, send me a verification letter. I'm sure it doesn't check all the boxes.
Yeah, whoopee. It probably doesn't.
I didn't even ask them for it, honestly. They just sent it.
Yeah, well, they do that to say they verified, but the reality is you got to be more specific, way more specific.
Yeah, what I did is I knew that we were working on this. So in my last hearing, my notices are working okay. I mean, I've done a pretty good job of kind of keeping them on their back foot a little bit. But they seem to be pressing forward. So I bought some time and I told them I was going to be traveling until October and I couldn't be in court until October. So I bought
Okay.
some.
Look at what's in there. You know what you've done. You have to discern
Yep.
when you want to shift gears a little bit, and get these notices out. Because again, everything we're doing there we're not making claims. We're making inquiries.
Exactly.
Hey, you proved your debt. Well, you can, and I guess one word you can use for all this is a conditional acceptance. In other words, you're saying, hey, well, if you say you got a claim, then just got to prove it. Here's what I need to see for proof. And I need witnesses who can testify to it. Otherwise, you don't have your stuff you're sending is just junk.
Yeah.
Remember,
And
paper in court with a lawyer alone is junk. It's not evidence.
And they do send an affidavit. I don't have it pulled out in front of me here, but they do have an affidavit, witness affidavit. Now this is from the third party debt collector, of course.
That there's a contract and that all these they didn't buy the debt. I mean, what are they witnessing? Yeah,
exactly. And what consideration was given,
Mhm.
they can't claim $5,000 on something they paid.
Well, the key we focus on in this is what are the violations of the law that we can catch them on, and then
Right.
they got to bring us a witness that can prove they didn't violate that. That's
Yeah.
going to be hard for them to do.
No problem.
It's pretty specific.
Yeah, I haven't had a chance to review a lot of the information yet, but I'll probably pick up with that where we
Yeah.
start. Get them responding, and I bought myself enough time so I could evaluate this.
There you
So,
go.
Yeah.
Yeah, I think if you go straight at them, it's really sometimes it's better, and just show them that if you don't verify this to the degree I'm talking about, then you haven't verified, and therefore you have no standing to go to court.
Yeah, I think I can kind of fold this into what we're working on here with this debt elimination from where I stand now, if you know what I mean. I can say,
Mhm.
well, if you're not going to acknowledge my acceptance, then we've got some other problems to deal with. is
Yeah. Well, there's just
what
very specific legal violations. What makes these debt collectors, these banks, pay attention is what their boss says. Their boss are these laws. They have to comply to them. A lot of people say, well, don't argue the law because then you're going to their jurisdiction. Well, you're already in their jurisdiction. I mean, the darn
Right.
contract's there. And the law is there over them. And what you have to do is identify where they've messed up and zero in on that. That's what makes them see. Nothing against the equity process, but there's sometimes it's missing the teeth that makes them
Exactly.
do something,
Exactly.
compels them.
Yeah, and I've kind of pushed that as far as dishonor, et cetera, you know,
And
and
by the way, when you're asking for verification, that is equity. You're saying I want an equitable remedy here.
right. I think I can fold it over into this. Like I said, I haven't reviewed the process. I have a general
Right.
idea of what it is, and I think I can say, well, if you're not going to acknowledge this, then we got to address this. Is
Yeah.
pretty much what I'm going to say.
Yeah. Yeah. Hit them up.
Yeah.
Just
Okay.
fire them off at them.
Yep.
Okay.
Exactly. Thanks, TJ.
Okay.
Yep.
All right. Rob, you're up next. Let me try that again. Didn't unmute. There we go.
Hey TJ, how you doing?
Good. How you doing?
Good man. I popped in a little bit late with the meeting tonight, but I was wondering, is there going to be like a regular scheduled day, like once a week, or Zoom videos like this, or anything
I'm
like
going to
that?
do a couple. I'm going to try to do a couple Zoom calls a month on this. Once we have pretty much this first set of modules done, and then people can actually come with questions about that, because I don't want people to get ahead of what we're doing. But because then I start asking questions about stuff we haven't even written and put on the website yet.
Right.
But in the meantime, there's plenty there to get started with. But yeah, we will get a schedule going exclusively for the gold premium members. It might be on alternating weeks when we do our regular premium member calls.
Yeah, I'll definitely be upgrading to it. So I just was wondering, when is it actually? It's already available to start right away.
Yeah, it's you can go there right now, sign up. People are signing up like crazy. In fact, we're kind of trying to get caught up a little bit on all the signups, which is good. A lot of people
Yeah.
seem to like what we're talking about there. So
Yeah, I went head to head with my mortgage company, and I already had some success with using one of your documents, and so I mean, I definitely believe in what you're doing. I just wanted to put that out there. So
that's
that's all.
awesome. Yeah. Well, if
Yeah.
you have a success with a document, we ask people to take a screenshot and send a little written testimonial so we can tell others about it. Tell them what you did.
It's not like I got the mortgage. It's not like I got the mortgage set off or discharged,
Right, yeah.
but I mean, they just
Yeah.
flat out sold my loan off. So I
Yeah.
mean, I was
Seen that a lot.
6 months. Yeah, and I was 6 months behind with them, and by choice, because they were doing some fraudulent things. So I just said, I'm not going to pay you, and then they
Yeah.
just flipped the loan to somebody else.
And
But,
I got
I
some
mean-
new stuff that we're gonna later on when we get to the mortgage module, which I don't want to cover till we've covered all the basics. But there's some additional things to do on a mortgage to stop them from going forward. Believe it or not, one of which
Yeah,
a lot of people go to court, start fighting with them civil court. You will lose if you go to civil court with them. But you can get them
Right.
you can actually hit them on small claims. You can hit them in arbitration. Nobody ever uses that arbitration clause. So we're going to have to give a more of a detailed presentation on how to do arbitration, because it's actually maybe one of the best venues, because guess what? When arbitration begins, all collection actions have to stop. And some arbitration cases take a long time.
Excellent
never have to go
point.
to
Yeah,
court.
that's yeah. No, that's exciting. I'm definitely into
Yeah,
it,
that's
man.
a cease and desist
So,
like a bankruptcy. And with the questions
Yeah,
we're asking now,
very-
the way we're asking them, we got some good questions to ask a mortgage lender now. So stand by for that.
That's interesting because yeah, okay, thank you. I'll let you take the next call or whatever.
All right. Thanks, Rob.
Thank
Appreciate
you.
it.
Look forward to it.
Brian, looks like you're up. Yes.
Can you hear me?
Yes.
Okay, question. It's kind of related to what Dave had asked earlier. If you have old accounts that are still showing up with the agencies that may have been closed a year, two, even maybe 3 years ago, that still show a balance, but they've been either sold or charged off or
Hmm.
whatever,
Hmm.
how would you handle those type of accounts for something like that?
Okay, in the credit, or the portion of the credit course, there's some information about just the various things you do with anything appearing there that's in error. Because if it's still there, technically, I consider that to be an error. So you need to validate with the credit bureau. There's some instructions there on how to do that, what to send. And in some of these cases, you may have to send something to that creditor and saying, hey, you're reporting this without my authorization. This is a violation of XYZ. You need to remove it until you verify it. And
Okay, so
here's
are
the
you
criteria. And the letters are very specific about what they have to do. If they don't respond, then you can pull those over and go back over to the credit bureau and say, hey, they didn't verify anything. And the bureaus themselves are supposed to remove it until they validate it.
okay? So are you saying then that you would more or less address the credit agencies first on that before you would actually go back to the original creditor?
Well,
Or
I would have to look at what's showing up and what it's saying and the circumstances. So, but if I know that it's maybe an easier removal, again, I don't have a black and white answer to that because I have to see what the report says. But you're going to hit them both. Let's just put it that way. You have to use your best judgment in terms of where to start. But I would hit them both. I would just start hitting the credit bureaus with the removal requests, verifying the debt, and remove it until they verify it. And over here, hit the other creditor up and saying, hey, if you charge it off, I want to see a copy of your tax records because you're now making a false claim because the amount cannot be correct if they charged it off. Let's say that you owed them $10,000, but they charged off $10,000. Well, they've taken a tax credit. So how can they claim that your balance due is still $10,000?
right,
If
yeah, I
they
see
make an
that.
erroneous
Right,
claim, you can sue them for that.
right. Yeah, there was just one. I think there was a charge off, and this was related all back to COVID-19. It's basically when
Yeah.
this kind of took place. But would you still basically send them the same type of letter that
Yeah. I
you're
mean,
sending?
obviously tailor it a little bit to the circumstances, but generally speaking, hey, you're still reporting this. So then boom, boom, it's the same letter telling them, I need you to verify this and remove it until you verify it. And by the way, if you're violating any of these laws, I will hold you to account. And then you hit them with three letters. That's your three notices. The last one is essentially you're intending to sue, and they're going to have to start sending you checks for reporting that. They're making a profit off your social security number without your permission.
In that letter, would you also include something in there that you do not give them any permission whatsoever to use or supply any of your personal information to any of those credit bureaus?
Well, yeah, that's what you essentially do. And if you're in doubt, you can always say, and I just let you know, any presumption that I did give it to you, I hereby revoke. You can,
Okay, so
since it's a unilateral contract, you're the one that created it and signed it, and they didn't. You can revoke anything.
okay, so you basically would be asking them to validate the debt and also tell them that you do not give them any permission to use or transfer any of my personal
Yeah, well,
information.
I can say I don't
Right.
have any evidence that I gave you permission to use that, and they can't produce it.
Mhm.
So I'd rather put the burden of proof on them. But I assure you, you might have given them some permission, but not to report it to other agencies, and like the debt collector, they had no right to start collecting on that.
Okay, all right, thanks.
It'll be in the documents. When you read the letters, it'll kind of flow when you start reading the documents.
Okay, thanks.
Okay?
Mhm.
Yeah, that's the general idea. You're really staying on point. It's a very simple point you're making with all these guys. John,
Hey, good night, everyone, and TJ as well.
how you doing?
Good. How are you?
Good.
My dilemma or issue that I'm going through right now, I was sent a served, but I actually wasn't served. But it's a $20,000 loan that I never paid on. Third party debt collector contacted me
Okay.
I initially sent them a letter. They stopped contacting me, and now they've sent served me. They filed a lawsuit. They actually served me at an old address, which I guess they're just trying to be sneaky because the address that they sent it to had nothing, was years prior to when it wasn't on the application loan. It's not,
And by the way, and this is why one of the things we do in credit repair is go in and have all old addresses removed, so they can't ever pull that game on you.
yeah.
But they've already done it. And
So, yeah,
again, you may have to look at the rules of your court in terms of what is proper service, but serving an old address may or may not be allowed. You have
yeah,
to look
it's
at it.
not allowed. It's not
Okay.
allowed.
There you
So
go.
I did answer. I did have, they gave the 20 days. So I did answer them. In one of the defenses, I put that it's not, well, it's improper service, improper venue. They did have, they have the affidavit with the certificate of service that I was served, but I was not served. They served, someone in another state. I don't even live in that state.
Okay, I'm saying these are all evidence items. If you go to court, you say, "Well, I want to have the witness here who saw me served."
Right. So, okay, well, thanks you. Yeah, I didn't know that, but so I do have a couple of defenses now. I do in the court. The court is set for a date next year, April 2025. But it does say arbitration. But I do have an arbitration clause. That's two separate things, correct?
Well, no, they're invoking arbitration. You can invoke it or they can invoke it. They have to pay for it, which is always not something
But
they want to do.
but they'll do, because the court hearing says non-jury arbitration. Can they do arbitration through a public court?
No, public court is
Right.
not arbitration.
Okay. Okay.
And
So
you
I
know
just
what? Then if they're invoking arbitration, great. Keep hitting them with all the possible verifications, and then when you get to arbitration, there's a process you have to follow, and it's almost all done by uploads and things like that. You don't even go to court.
okay.
But
Because as of right now, everything is being handled through the court. I have the how to win in court. I got that course. I do have to
yeah,
do it
well,
thoroughly.
arbitration is only different in that you want to set up all your verification documents, show they haven't proven a claim, and simply show that they're violating the laws. And they probably won't want to go through with arbitration. It's all about intimidation and smoke and mirrors. Arbitration is to your benefit if you're prepared.
Right. So while I did send, they just got they were just served yesterday from my answer. That was just yesterday. Should I the when you're saying ask them these questions to prove and show what laws they're violating, am I
Yeah,
saying
start with
sending that
the
directly?
same letters that we use. Just start hitting them on those things. We're going to require responses to this and do the.
And that will be out. Well, obviously that'll be outside of court. This is just between me and the attorney.
Yeah, you're just verifying debt, verifying contracts, verifying questions.
Okay.
And you're offering them essentially an opportunity to settle the matter. And I will only charge you $1,000 per violation per the Fair Debt Collection Practices Act.
Okay.
I'm not paying them, they're paying me. You got to have that mindset that that's what you're going to do.
No, of course. Okay. So I know I have, even with this court, the new course that will help because I have about a year's time.
Yeah, you'll in 30 days you can pretty well be set up. You want to read up just if you want to look up something about how to do arbitration and so forth. I'm researching maybe even some third-party videos to put up on that too, just as a general principle to understand how it works. But essentially, if it does go that far, and it probably won't, but if it does, they tell you how you upload your evidence, and all your verification letters are going to be key to that. Yeah.
But have you ever seen a case like that where they're calling you into court, but the type of court cases called or headed as an arbitration?
Sure, arbitration's a part of the contract, in fact, the courts want you to do arbitration because they don't want to be involved if it can be resolved first. This is
Right.
Matthew 18, verse 15, 16, and 17. They follow the same rules as in the Bible. Matthew 18, verse 15, you go to your brother and you speak to him. Second one, you bring a second witness. That's arbitration. Third
Okay.
one is court. It's actually been outlined for 2,000 years. They follow that process. But if you follow it, it's to your benefit. It's when
Right.
people jump ahead and start suing without having done doing the due diligence and the proper opportunity for them to respond and prove a claim, then you lose because you didn't follow procedures.
But what I'm really trying to question is how would they do arbitration through the court system? Isn't arbitration
It's not a court
private?
system. Arbitration is a private process
Is a
out of
private
court.
process?
They're
Okay.
ordering it. They can say, well, we want you to go to arbitration because there's an arbitration clause. Okay, no problem. See, they think that
Understood.
you'll be intimidated by arbitration, and you should think just the opposite. First of all, you want to prove they don't have anything to come to arbitration with. But
Yeah, I had that
arbitrations,
also in one of my defenses as a lack of standing.
yeah. Well, again, if you've documented it well enough, they've now not verified the claim, then that's your whole claim in arbitration. They don't have a contract.
Okay.
And you're asking for this accounting. Where's the accounting of you took a tax benefit? I want that adjusted to the balance you're claiming. Otherwise, you're making a false claim, which is a violation of several laws. You
Right.
see,
So
you
that
get them on a false claim, they're stuck. Stay on that. Don't say, I'm a patriot and I don't have to pay tax and pay anything. That's the wrong way. The law says they got to make accurate claims. Well, how can it be accurate if they've taken three benefits? They've collected
right.
insurance, they've collected tax benefits, and they've probably sold your information. I want
And
the accounting for that added to when you say providing the accounting. I want that in the accounting too.
and you're saying the third party debt collector is the one who's taking out insurance on this. Is that correct?
No, usually the bank did when they sold it. Remember, they're the ones really making a claim. The third party debt collector, you have no contract with unless here's how they get you. If they sent you a letter and they gave you 30 days to respond. If you didn't respond, it says in the letter, oh, then therefore you agree. It's a default
Right.
letter.
I didn't respond.
Okay, well, that puts you at a little bit of a disadvantage, but it doesn't mean you still can't hammer them. But the automatic killing of a debt collector is this is why these letters are so important. Immediately, never hide. Don't try to make sure they can't get the mail to you. You want to get your mail so you can respond quickly, because the more responsive you are, the better you're standing.
Okay.
Yeah, because they verified a claim by your non-response. They're doing the same game we do with them.
Right. So
Oh, your
is there
silence is your agreement.
right, silence is acquiescence. So how do I reverse that because I didn't
Well, that's hard to just reverse. I don't assume it's a rule. If you fail to do it, you put yourself at a big disadvantage. Okay. But now, prior to arbitration, there's going to be procedures. There can be things you can still be demanding and wanting to see. You still want to verify that there really is a contract. Again, they'll use a default letter, but that alone is not sufficient. You can still say, well, but okay, let's not argue whether you have standing. How about we argue whether you're making an accurate claim?
right,
All right.
okay.
The accurate claim is 15 U.S. Code 151666, and they must be accurate. To make inaccurate claims, now they're violating other laws. And they'll say, "What here's your statement that says you owe $15,000." No, I didn't ask for that. I asked for the accounting on the entire account, which is the securities, the insurance, the tax benefits you've taken. I want to know that the underlying debt that supposedly there's a contract for, I want to make sure that the number is correct. So I want the accounting so we can actually come to an accurate number. Oh, and by the way, if you're making a false claim, you're making a false claim into court. That's perjury, Mr. Attorney. Are you sure you don't want to talk about this outside of court?
Right, okay.
You've got to go at it like that. So it's about
Okay.
accuracy now.
All right.
Okay?
All right, TJ. Thank you.
You bet. Okay, wait a minute. Was that John I just did? Yeah. Okay.
Yes.
Gotta lower your hand so I'm not confused. Jeff, you're back.
Yeah, can you hear me okay? Yeah, I just kind of want to make a comment on that arbitration. My experience with it has been sometimes it's a pretty informal hearing that they have like a board of attorneys on it, 3 attorneys. Some counties will have mandatory arbitration. They're trying to save their trial docket from getting too
Yeah.
bogged down. So it sounds like that can actually work to our advantage if that's the case.
Yeah, as long as you know the rules of the game, like anything, and you have built a good record.
Yeah.
That they have not verified the claim. And like I said, even if they don't verify, you can go to the accuracy argument and say, well, I want the full accounting of these things, including the securities, any back-end securities that were generated from the account, because they all have tax benefits they took. The charge-off is a tax benefit. The insurance claims they file, because they file insurance claims. I want that accounting brought in so that the number we're talking about is accurate. Now that ties them up because they really won't want to produce any of that because they don't want to acknowledge that you actually loan them money. And they're making money off of it.
And if they've sold it to a third-party debt collector and they're claiming the same amount that's on your last statement, right there, they're not accounting for what they received from the third-party debt collector.
Exactly. You want to know what they paid for it. The third party debt collector is the one suing you. So I want to see all that information for the underlying debt and also what you paid for it, so that we can actually talk about an accurate number. And if you're making an inaccurate claim and you cannot verify that claim, then you're taking the position that they're lying to the court.
Yeah.
They have to be.
The third-party debt collector can't voluntarily they haven't suffered any loss.
No. Exactly.
I mean,
who are they going to send as a witness that you signed a contract with them and they suffered a loss? Oh, and that their claim is accurate. Accuracy is the big one, man. You can get them, even if you screw everything else up, you can focus in on accuracy. They cannot make an accurate claim without lying.
Yeah. And I think the limit on small claims generally is, I think, 10,000.
Yeah, most courts is 10,000. So don't go in there for anything more than that. Just keep it within the bounds. You're not there to make a lot of money. You're there to make this go away and maybe get paid something for your time.
Yeah. Okay. Thank you.
Okay. All right.
Bye.
Justin.
Hi, TJ. This is Justin again. I was just listening in, and there was a guy who was just saying who defaulted on responding to the debt collector within the 30 days.
Yep.
So I'm looking under FDCPA, under Section 809, validation of debts. If I'm reading this correct, for that guy and also anybody else who don't respond in 30 days, it says FDCPA Section 809, subsection C, admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer. There's your way out.
That's your way out. Yeah. As I say, you just got to understand they're going to try to trick you in by saying you have a contract. Reality is it doesn't change the fact that they really don't have a contract. It doesn't validate it. Plus, you can hit them up on the accuracy stuff, and they'll want you to go away when you start hitting them with enough questions, especially a third-party debt collector. They know they're always violating the law just as just a matter of regular routine. They have no standing, but that's a good point. Thank you.
No problem.
Very good. That's what why it pays to look things up, guys, because again, we have a whole list of the reference laws that you can also go click on and read up. You're definitely going to have to read a few of these things. Doesn't sound very exciting, but it's better than being broke. So, and it's a nice thing to know. Very good. Good job. All right. So I don't have any other hands raised at the time. We're up against our time here pretty quick.
Did I get in a quick one?
Sure.
I saw something about unlimited wealth. Where does that come in?
Where did you see that? I don't know what you're referencing.
I saw it on one of the pages, and the title of the current course is it also mentions wealth, like the gold course.
Yeah, well, I mean, if you think about this for a minute, if you understand how to create credit accounts, discharge much of them, buy things with that, or invest in things like buy businesses, buy gold, whatever, and you can understand how to master credit like that, can't you create unlimited wealth doing that? That's the basic idea.
Yeah,
You're getting access to a lot of money.
That's my idea. Yeah.
You just gotta don't overdo it. You still want to do something with it. I mean, you got to build a business or something productive, but access to credit is really the key to everything. I mean, I always say, like Donald Trump or not, but the guy knows how to use credit, and he built his empire on credit. Robert Kiyosaki. I personally met with him and spoke to him about this. And he says debt is good when you understand how it works. You can create massive wealth with debt because you're learning how to take debt and be productive with it rather than let it be destructive to you, which is what most people do.
Excellent. Yeah.
Yeah. So hopefully that clarifies that. I didn't really make that strong
that's
point.
good. Well, all so-called money in our society is debt anyway. So
It's also so-called money. It's really credit. And who's the creator of the credit? It's the one who creates the security instrument that then goes into an account, which then funds the credits out of the Federal Reserve back to be used for something. But who's the one that originated the security? That application, the contract, is the security. You create it.
Yeah. Right.
That's how it works. That's the way money actually works. So once you know that, there's a lot of moves you can make. Okay?
Thank you, TJ.
You bet, Dave. No other hands raised? Okay. Well, the only other announcement is for those who are in the new class, where you will get additional updates. We'll probably, actually, this was a great question tonight. I'll probably go ahead and post this maybe up there as an introductory class for people to listen to anyway, to the gold membership as well as the premium members. So tell your friends about this new program, because it's, you guys work together studying on it or something, you can get better at it. Maybe you can develop and master credit, build some wealth. There are some things we can talk about. I won't get too much into the tax side of it, but if you don't owe too much in taxes, sometimes you got enough credit, you can just pay that off and just do this with the credit. It's easier to do that. There's other things you can do with taxes, but we don't cover that because you don't create you kind of create that by filling out a darn 1040. You actually create that debt too, but it's different than what we're talking about with bank debt. But you want to avoid it, then look at our status and trust course, because you don't have a lot of taxable income. That's the key. It's not about not paying taxes, not having taxable income. Very qualified word. And that course teaches that, but that's an entirely separate subject. Again, we want to make the focus of this how to get good at mastering that credit system. Okay. And then building wealth from there. So if there's no other questions, which there aren't, I think that's where we'll call it a quits tonight. I appreciate everybody being here, and we'll get this posted here shortly.
Hey.
Thank you very much, TJ. God bless.
You bet.
Appreciate it.
Thank you.